Welcome to the Southwest Florida Real Estate Update, hosted by the York Group of Downing Fry Realty. Our show will bring you the most up-to-date information on the local real estate market, presented by leading experts in the field.
Hi, welcome to the Southwest Florida Real Estate Update. I'm Morgan York with the York Real Estate Group, and today we're joined by our host Jim York and his guest Celia Deifik, attorney with the law groups Lanier and Deifik.
Thank you, Morgan, for the introduction. Well, thanks for coming on the show. It's been a while.
Yes, it has. I'm happy to be back.
So the viewers that maybe haven't seen you on the show before, because it's been a while, why don't you just tell them a little bit about yourself?
All right. I am board certified in real property law and have been since 1990, but I focus on litigation. I litigate real estate matters with a law firm downtown, Lanier and Deifik, and been practicing for more than 3 decades. Don't want to tell you exactly how much more.
Okay, well that's good. And people can get a hold of you. We have their name and phone number on the screen here. So let's talk about condominium and board of directors and associations and, you know, control and what they're implementing that maybe the homeowners aren't in favor of, what kind of control they have on doing things.
Yes, this is an interesting topic these days, and as I said, I've been practicing law in Florida for many, many years. And during the first few decades, what we found was that the Florida courts and the Florida legislature generally bent towards the benefit of the board, because they were very aware that the board of directors are volunteers, and to some degree, let's face it, board members have to herd cats. It can be a very difficult and unforgiving job, and you don't get a lot of thanks. So the legislation and the courts would bend towards the business judgment rule, that, you know, let the board interpret the rules and the law and have the board have some latitude in making decisions. And we've seen that, as I said, for some decades. More recently, however, because there have been a lot of corruption scandals uncovered, I think I was on the show once and I talked about a major grand jury investigation in Miami-Dade, where property managers and condominium board members were basically skimming from and taking gross advantage of owners. There has been a push to make the rules more lenient for the owners and harsher on board members. Now, I think this did start in deference to the legislature. It did start certainly within the last 10 years or so, where there were the arbitration proceeding was set up and complaint proceedings were set up, and perhaps even further back than that, because the legislature is aware that the unit owner does not have the deep pocket that the board members do. Because of course, board members have insurance and they can bring in insurance defense. In the last 3 or 4 years, we've had a bigger movement, I believe, with the legislature and the courts to create a level playing field for unit owners. Now, you and I were talking about different restrictions that may be imposed on approval of purchasers, saying we're not going to approve a unit owner's proposed sale unless the purchaser meets all these criteria that we want.
That's right.
I think there's a dispute now concerning turning people down because you don't like their credit score, those kinds of things. That is really a slippery slope. I will tell you that there's a few problems with that. Yes, there's some reason to impose some reasonable criteria for your purchaser. And to a lot of people that makes common sense. The problem can be when it's arbitrary, when the restriction is arbitrary and or it's arbitrarily applied. We also have to think about the impact of federal law. And I want to lay this out a little bit more for you. A guiding principle that was set down by our Florida Supreme Court many years ago is that condominium restrictions or limitations may be enforced if they serve a legitimate purpose and they are reasonably applied. Devil is in the details.
Right.
There's been a lot of disputes about restrictions put on approval of purchasers. For one thing, it interferes with the unit owner's ability to sell their unit, and it interferes with a very old, long-standing principle in Anglo-American law that we're not going to interfere with people's free rights to convey property. Secondly, there are federal laws such as the Federal Fair Housing Act that have more and more been interpreted to prevent communities or boards from sale to people that they might not like for other reasons. So you have this concept of imposing a disparate impact. That's a lot of $64 words that basically say, we're not going to let you impose barriers to people buying property, people who may be of a socioeconomic status that you don't like. There is an arbitration decision a few years back, and it may be different than the dispute that you were thinking of, where they found that the board's imposition of a credit score and financial restrictions in denying a sale was arbitrary and just egregious, just bad. And the arbitrator struck down the board's disapproval.
So we were also talking before the show is they would have to change certain documents, correct?
Yes, and this is, I think, one of the most important things, and it's always one of the first questions I ask when people come in and they say, there's a rule or the governing document that says I can't do X. First question I ask is, which document? Because there's a pyramid or a hierarchy, if you want to call it that, of documents. The Declaration of Condominium is the Bible. It's the most important, and it is the hardest to change. And there's a reason for that, because the whole purpose of the condominium regime is we're going to impose covenants on your land. We're going to impose restrictions, but you're going to know about them before you buy, and they're going to be hard to change so that you don't get hoodwinked or sideswiped. The next level is the bylaws. The bylaws govern the board and how they're going to conduct business. They're not quite as hard to change as the declaration. Then there's the rules and regulations, which are really super easy to change. The board can do it at a board meeting without really discussing it with the owners, and the owners don't have a vote. And so sometimes, certainly not always, but sometimes we see that the board has gotten a little bit carried away, creative, and they have made a change in the rules and regulations, for instance, as to approval of new purchasers, or as to approval of leases, or how many times you can lease.
That's right.
And things like that are not acceptable because
they don't match the
Bible, the Declaration, and the owners have to vote to change the Declaration.
So when we get from our closing agent, our attorney, we get the documents, okay, because we want the latest file, okay, and usually that's what you're talking about is the documents. We present it to a potential buyer, or we get it for our seller, whatever, and that does not match the other part. That's going to create a problem, right?
Well, it's going to create a problem.
For who?
Have been Well, it may create a problem for the board and be an advantage to the owner. Now, of course, every scenario is fact intensive, and I always wait till I see everything before I make a decision. But for instance, I have had people come in and they show me rules and regulations passed by the board that say, you know, we're not going to approve a purchaser unless A, B, C, and D.
That's right.
Well, the first thing that I do is I go and I look at the declaration.
Right.
And if it doesn't match the declaration's restrictions, I'm going to be writing a letter to the board saying, I don't think we're going to, you know, abide by this. Now, obviously, there's always, you know, exceptions. The board has a right to say you're not going to have, you know, put in the rules, you're not going to have loud music, you're not going to have glass by the pool, things like this.
But to change those documents costs money, right?
Well, it costs money.
So is that one of the reasons why they don't change them?
Well, that is one of the reasons.
Because it has to be filed with the state, right?
Well, it has to be filed with the clerk of court in the official land records, but more importantly, to make changes to critical things that affect your ownership. And when we talk about approval of your purchaser or how many times you can lease, this goes to the basic reason you bought this property.
That's right.
The basic reason, this goes to your right of your property rights in this land. They would have to propose an amendment to the declaration. It should be written by an attorney. I've seen ones where they have tried to do things without an attorney, and sometimes they shoot themselves in the foot. I think often boards have retired attorneys from other states, and they say, well, you know,
that's right,
we can do it.
Exactly.
Now, in fairness to the board, many times the limitations or restrictions that they impose are things that the owners do want, or the majority of the owners do want. Well, then propose the amended document, the amended declaration,
and change it.
Send it to everyone, hold the appropriate meeting, or sometimes you can do this by written consent, and change it, and then you avoid a lot of problems. So.
Okay, well, let's take a little short break here.
Okay.
We're going to get a little background about the York Real Estate Group that sponsors the show, and we'll be right back in a couple of minutes, okay? Thank you.
Thinking of buying or selling a home in Naples, Marco Island, Bonita, or Estero, Florida? Think of the most experienced York Real Estate Group, associated with the #1 brokerage in Southwest Florida, Downing Fry Realty, which produces yearly real estate transactions of over $1 billion. Jim, Michael, and Morgan make up the York Real Estate Group of Downing Fry Realty, with over $275 million in sales transactions, along with offering over 25 combined years' experience in the local market. The Yorks can offer the experience and trust you need in a realtor. Call them today at 239-273-6727 or visit their website at www.naplesyorkrealestate.com.
Welcome back. What's Tallahassee and our
illustrious lawmakers doing?
Lawmakers doing to change all this?
Well, I think that the lawmakers, to their credit, have been continuously trying to update the condominium statute and also the homeowner association statute, both of which have become more complex over the years. In the last couple of years, there were some very major changes to the condominium statute, which we've talked about on this show.
Right.
And one thing that has been puzzling to attorneys and boards of directors is some of that language was written a bit too hastily. It's like whenever you do something by committee. And so a lot of questions have arisen. So this year there's a few bills pending in the legislature. And you know, originally I thought of them as just glitch bills. We're going to fix these little glitches, and I'll tell you what some of them are. I think they're trying to go a little bit further and put some more restrictions on boards of directors ensuring that they meet their fiduciary obligations to unit owners. Now, I always like to be fair to both sides. I primarily am representing owners against associations, but I'm very sympathetic to the burdens that these volunteers on the boards meet.
True.
For instance, let's talk about a glitch first. There was a provision in a prior amendment that said a person who was going to serve as a board member could not serve more than 8 one-year consecutive terms. Well, that's a little puzzling because boards of directors generally have staggered terms.
That's right, they do.
Where some people have a 1-year term, some people have a 2-year term, and does it apply to people who have 2-year terms? And was it retroactive if you've already been on the board for 5 years? Does that mean you only have 3 years left? So this was one of the simpler things to fix. And the way the legislature is proposing to fix it, and of course this is just a pending bill, it has not been voted into law yet, is they're making a provision that says you can't serve more than 8 consecutive years. However you got there, you can't serve more than 8 consecutive years.
It could be 1 or 2-year terms.
Right. And also, they're only making it prospective, but from July 1 of 2018. So there's a tiny bit of retroactivity in here. So you're going to have to measure your terms from July 1 of 2018. So that's fixing a glitch. A much bigger change is they are proposing to do away with pre-suit arbitration and instead require pre-suit mediation, which may speed things up and make it easier for people to resolve things. And it's also going to make it a bit easier for people to eventually get to court and get a resolution. Another thing that's happened is we currently have a lot of certification requirements, and so they are sort of adjusting what the requirements for these mediators are to be sure that you get a mediator who truly knows the law. Now, there's a lot of other changes pending, but I think that those are some significant ones.
And they would go in effect in 2020, I would take it.
Generally, they go in effect the summer of the year the legislature sat.
Okay.
So most of the time we see these things take effect July 1 of 2019, if it's a 2019 legislative session. The exception is, as I mentioned, with the board terms. Something else that's going to be, I think, very important to people who may be dealing in the future with hurricane damage, for instance. That was a big deal with Hurricane Irma.
Right.
And I get a lot of calls at my office about water damage and things like that. Is the pending legislation prohibits individual homeowner policies from having a subrogation right against the association. I don't know if that's going to pass, and I think it's going to be somewhat controversial. So.
And we were talking before the show, we were talking a little bit about, I think we've covered enough on condominiums, okay? Is developers and buyers having remorse and getting their deposit back, or what were we mentioning about that? Oh,
well, we talked about that quite a while ago. During the last, say, 12 years, particularly after the Great Recession started, and let's say from 2009 to, say, 2012, there was a huge amount of litigation, and I did some of it on what we call deposit recovery. Then it became not as relevant because construction fell off.
That's right.
So it developed because while there was a big boom in real estate, in 2007, for instance, a lot of people were signing contracts to purchase from developers.
True.
Where it was to be built within 2 years. And the developers were seeking to be exempt from the Federal Full Disclosure and Fair Sales Act. And what happened was those provisions were not as well written as they could be, and there was a lot of litigation, and developers were forced to give back a lot of deposits. Not just because of the federal law. Well, we're seeing a little bit more of that now because there is a construction boom. So you're having more people who are purchasing and perhaps changing their mind. And I don't want people to think that it's only the federal law that can permit them to get the deposit back. You see a lot of failures to comply with state law, or simply failures to finish the contract. So many times people bring contracts in, they're not fully executed. People have made changes, not everyone has
signed off.
Not everyone has gotten their condominium documents as they were supposed to, things like that. But we're not seeing that in the volume that we had been before. What we are seeing is a move, as I mentioned before, by the legislature and the courts to make sure that people get fair access to the information once they purchased, fair access to their official records and things. I'm sorry, I might have changed the subject on you.
No, that's good.
Okay.
We have a couple more minutes. What else would you like to cover that could help our viewers and people that are buying or selling?
All right, well, I would say that the recall provisions have been changed quite a bit in the last few years, and they're going to be changed again, and it's made it a little bit easier for owners to recall directors who they're not happy with. But you have to be very careful because there's a lot of fine print. One of the things I've seen, unfortunately, is while I would say 90% of the board members do their best. They really try hard. There is an element who tries to take advantage of their position, either by excusing themselves from assessments or awarding contracts to friends of theirs, things like that. And the Condominium Act, and to some degree the Homeowner Association Act, is getting tougher on them and imposing criminal penalties and sometimes civil penalties up to $5,000. Now that's a very broad brush, but I just want people to be aware of that.
Is there any kind of law in the books, like if they're getting new roofs put on a condo or something, that they're required to get more than one bid, so that would prevent them, you know, the association or a board director using their friend to do it?
Yes, they are required, and every declaration tends to be a little different because it's usually based on a percentage. If it's going to be more than a certain percentage of the association's budget, then they're required to let it out for bids. And they're required to keep the bids, and that's an interesting point under the pending legislation. The association is not required to accept the lowest bid, but they have to be prepared to justify why they didn't. So yes, that's true. But one of the things that we were finding, and I think I experienced this with some of my clients, is we said, did you let it out for bid? Oh yeah, sure, we did. All right, let us see those.
Right.
Oh, we didn't keep them.
Exactly.
Or we can't find them.
Right,
or
we've heard that.
Yeah, that kind of thing. So the new legislation, which I think will pass, is requiring them to keep all of these kinds of things and to have backups. So you can't say, gosh, when we moved, all those records were lost.
Right.
My dog ate my homework,
Right.
kind of thing. And there's, you know, they want to impose penalties on board members who don't do that. They're also making it a bit harder for board members or property managers to restrict your access to those records, because the statute has always said that you, the board, can impose reasonable restrictions. I don't want Jim sitting in my office every day going through the filing cabinets. Well, some boards were getting a little too hard-handed with that. So the legislature is trying to make it easier for owners to see that. Now, another very interesting topic that we don't really have time to discuss now is the huge push-pull going on between the lending industry and community associations about lien priority. We've seen during the foreclosure crisis, community associations aren't getting their assessments paid by owners. Foreclosures take 8 years, and the association only gets 1 year back of its dues. And so there's a big push to fix that in some fashion.
Well, I appreciate you coming on the show. I've learned a lot, and I hope our viewers learned a lot. I'm sure they have. And if they have any questions on the bottom of the screen, they could give you a call. And we'll see you next week at our show next Thursday. Thank you.